Thank you all for joining this webinar. Today, we will be discussing economic substance regulations in the UAE in collaboration with Elnaggar and partners. Next slide, please. To begin with, I'd love to actually offer a brief overview about HAQQ, the company that organizes these webinars. We were founded to digitize justice, make it more accessible, and empower lawyers with technology such that lawyers actually make use of AI and technology so that it becomes their greatest asset and not their greatest threat. We encourage lawyers to use technology, and we've done so far as much as creating our own legal practice management software called HAQQ that offers brilliant benefits for law firms worldwide, being adopted by more than 6,000 lawyers, and we recently signed with the Tripoli Bar Association. Next slide, please. We encourage everyone to go to lawyer.haqq.me to claim your free HAQQ account, or just to understand what HAQQ is all about. By going to that website, you will see why people love HAQQ, and perhaps you love us too. Next, please. HAQQ is led by an international board of directors from all continents, featuring certain companies comprising the board of directors, including Kabalan & Kabalan, the Emirates Legal Network, the Lebanon Law Review, the LBG, Talabat, Hyperloop, Razor Capital, and Cymax. Next, please. A big part of the reason we do these events is because we really believe in the community. We really believe in enriching lawyers all around the world and giving back to the community, really showcasing the talent all throughout the region, such that the best lawyers connect together and really join and kickstart the legal revolution. Next slide, please. And that's why we organize the biggest legal events in the MENA region. Our flagship event, held every year, called Lawyers of Tomorrow, gathers thousands of lawyers from all around the world regularly to discuss the latest in AI and technology as it affects the legal sphere. Next slide, please. Today's guest is a very dear friend of mine, and I am honored to be on the board of the Emirates Legal Network, of which he is the president and founder. Mr. Ahmed Elnaggar is the managing partner of Elnaggar and Partners, the founder and president of the Emirates Legal Network, and the founder of The Jurist. You may have seen him because he is one of the best legal tech hosts, podcast hosts in the world. I say this with all sincerity, and you should definitely go out and watch all of his podcasts. He is highly successful, and we are always, well, speaking for myself, I am always lucky to learn from him, and I'm lucky to call him my friend. Mr. Ahmed, the floor is yours. The format for this event is Mr. Ahmed will be providing this webinar, after which you will get a certificate and also access to all the files and all the assets. Once the webinar is complete, there will be room for questions and answers, and we encourage you to interact with the speaker through writing in the chat box. Thank you very much. Mr. Ahmed, the floor is yours.
Thank you, Antoine. Thank you so much for the kind words, and I'm very happy to be here among the audience, and I'm always very happy to join HAQQ in their amazing events and conferences, webinars, and all of your activities. That's actually a very nice thing. Let me give a very quick introduction to myself. My name is Ahmed Elnaggar. I'm from Egypt, and for the last 15 years and more, I've been working and living in the UAE, between Dubai and Abu Dhabi. And a few years ago, I've established The Jurist, which when we started was all about sharing knowledge and sharing expertise between us. So we created a platform for lawyers and legal consultants working and practicing in UAE to share their knowledge and to have it accessible for the public for free. And from there, we also started Emirates Legal Network, which acted as a community for the lawyers and the legal consultants, whether working in private practice and in-house, in the UAE, to basically connect them and to be able to speak to each other every day and communicate, exchange business and exchange ideas, maybe argue some legal topics and update each other with the legal knowledge. And this is working out very well. And now we are a registered nonprofit association, and we have more than 600 lawyers among us, ranging from students up to very senior ones in private practice and in-house, even compliance officers and many people working in the same ecosystem, like legal translator, notaries, and so on and so forth. So take a little bit of a moment to check each of these projects, and I hope you get inspired or maybe join one of them in the future. Let's go to our topic in the next slide. Today, I would like to be speaking about the economic substance regulations in the UAE. And let me give you a very quick background about the topic. Economic substance, unlike what a lot of people might think, that this is something that comes from United States of America, where a lot of the regulations pertains taxes and compliance or corporate governance in general start. This one has started in Europe. And the reason behind that is that the European Union realized that so many of the American companies, so many of the big conglomerates of business, like, I don't know, Starbucks, Coca-Cola, and so on and so forth, are doing business significantly in European Union and paying very low taxes. And the reason for that is that these entities, when they come to Europe and they do business, they try to enter the European market with offshore companies or with companies that has very low economic substance in every European state, and they keep most of the profits in these entities. And these entities are usually registered in countries with a very favorable tax regime that absorbs all the profits, like, I don't know, Guernsey, Jersey, Panama, British Virgin Islands, Curaçao, and many other examples of this. So what they did is that in response to this situation, the EU and the OECD have created new policies. No, stay on the previous slide, please. Have created new policies to guarantee that these companies cannot escape paying taxes in Europe by creating the economic substance regulations. And the economic substance rules that was introduced are in most of these jurisdictions are very broad, similar. And the idea, again, is to enforce these regulations in countries where the tax regime is very favorable or the taxes are very low, whether zero or very low taxation in this case, to avoid paying high taxes in other jurisdictions like, I don't know, Italy, France, Germany, and all these European Union countries where tax brackets are very high. So these recommendations by these organizations basically enforce it into the smaller states, and UAE is one of them, where we had zero tax until very recent. The introduction of the corporate tax is a big change for us that will happen starting this year, but until very long time and until last year, the UAE was enjoying 0% in the corporate tax. And by implementing these regulations, was very similar across all the countries where the taxation are very low or even zero. The companies operating in these jurisdictions, so in our case would be the UAE, for example, will have to go through identifying if these companies are doing any relevant activity or not, and pass 3 types of tests. The first one will be called directed and managed in the jurisdiction test. And the second one will be core income generation activities test. And the third one will be the advocacy test. And the purpose of identifying if the company passed all these three tests is to understand, does this company have enough economic substance in the state or not? Because if it does, there's certain regulations passed to it. If it doesn't, then there is a different regulation that passed to it. And the whole purpose is to understand the whole concept. And the main point is to understand, is the formation of this company and the existence of this company main purpose is to avoid paying taxes in another jurisdiction or not? And this will be more clear in the next slide. Please come to the next slide. Sorry, can go to the next, yeah. So to identify and understand this, we have to go to who is subject to the UAE economic substance regulation. And for this, there are two distinct definitions for whoever is a licensee. So an entity that is registered in the UAE, a judicial person, an incorporated inside or outside the UAE, or an unincorporated partnership registered in the UAE, including, for example, companies or entities that are registered in a free zone or in a financial free zone and carrying a relevant activity. We are going to define later on what is a relevant activity, but you have to remember this very well, because the wording of relevant activity will be the factor to define a lot if the economic substance regulations will apply or not. So a licensee can be a private company limited by shares, can be a foundation, which is known in the Middle East as WAQF. That is majorly used for charity purposes, but in the UAE, we have a foundation that is used for a personal and for a private purpose, and whether it's a branch or a rep office of a company registered abroad. And the regulations apply for the licensees who are earning income from one or more relevant activities, and for whichever company or license that existed and is for its financial year starting the 1st of January 2019, when this regulation became applicable and working in the UAE. We can go to the next slide. So who is going to be subject to the UAE economic substance regulations? So a UAE business become a based on whether it undertakes a relevant activity or not. And a licensee needs to then, if it is found as doing a relevant activity, a licensee needs to demonstrate economic substance and show how much substance exists for this company inside the UAE, and define if the gross income was earned from that relevant activity or not. And for this purpose, we have to understand that the gross income will be defined as all the income, regardless of its origin or form, including revenues from sales, services, royalties, interest, dividends, and any other source. So any kind of income that a company that is being found doing a relevant activity within the UAE, based on the definition, will apply and have to comply with the economic substance regulation. There are some exceptions where the licensee is not required to meet the economic substance test or file for the economic substance report in a financial year in which it has no relevant income. So, for example, some of the companies would be found doing a relevant activity, having a license, and it should fall under the economic substance. But if it's not generating income in that year, then it does not have to demonstrate the substance and the economic relevance here for that year. And to be able to show the economic substance, a licensee must perform mainly the core income generating activity test. Because within this 9 points or 9 activities that we will list later on, and it will come very soon, we have, like, for example, one of the activities that would be defined as a relevant activity, and the company will be doing it in general, but there will be a different activity that is not within the list of the 9, but this will be the one which is can be described as the core income generating activity, then it will not fall under the regulation. We will explain this in a further examples later on. Can we please go to the next slide? There's some exemptions to this regulation into some cases and some businesses in general, and these exemptions we will list it here. So certain type of entities are not obliged to fulfill the economic substance test, but they still have to notify. So for example, an investment fund that is registered in the UAE are exempt from being reporting on proving substance in the country, but they have to still notify the authority whether they are doing a relevant activity or not. Entities that are tax resident in the jurisdiction other than the UAE. So for example, an entity that is a branch of a French company, for example, and this branch is taxed already in France because of the nature of the operation of that company, and it is already paying taxes in the other jurisdiction outside the UAE. These entities are exempt, and for that they have to make the notification. They have to apply for the exemption to be listed out of the obligation to fulfill the economic substance test. Another example as well, the entities who are wholly owned by UAE residents and meeting some conditions, like not being part of a multinational group, for example, or all the activity are conducted within the UAE. So I'll give you a very simple example. Elnaggar and Partners is wholly owned by a UAE resident, which is myself, and we are not part of a multinational group because we are operating in the UAE mainly, and all the activities here are conducted within the UAE. So in that example, if a law firm or any big kind of business or any kind of operation that is wholly owned and controlled in the state and at the same time is not part of any multinational group, then these entities are exempt from fulfilling the economic substance obligations. As well, licensees that are branches of foreign entity with relevant income is subject to tax in another jurisdiction abroad. Next slide. Yeah, here we have the list of the relevant activities which the UAE economic substance regulations apply for. IP, intellectual property business, shipping business, headquarters business, investment fund management businesses, banking services, service center business, holding company business, lease finance, insurance business. All these activities, if any entity are doing this business inside the UAE or registered as doing this business inside the UAE, will be considered deploying or doing a relevant activity. But in this regard, I would like to highlight a very, very important point. Many businesses are registered with a certain activity, but because of the nature of the business they are doing, they kind of operate outside of their scope. So to identify if a company is doing a relevant activity or not, what's important is really the substance over the form. So always remember this term, substance over form. So if a business is registered, for example, as let's make an example like a general trading business or trading in art pieces or in artifacts, and that is what the license is issued as, and that's what the relevant, that's the main activity is declared to the government to be. But in reality, the license is used to act as a holding company business. So what is important here to identify is not what the company is licensed to do, or what's mentioned on the trade license, or what's mentioned on the memorandum and articles of association. That's not what's important here. It has a certain importance, but what is important is the substance, is the reality. Is the company doing really insurance business or doing business as a service center, even if it has a license that does not fall into these list of 9 activities? What's important is to understand what the reality of the business is doing. And then here we'll say also geographically mobile activity. So it doesn't matter where this company is registered. If the company is even registered abroad, but is doing the business here in the UAE, that is where the UAE economic substance regulations will have to apply. And in this case, no gross income threshold is applicable. So it doesn't matter if it's doing $100,000 a year or doing the $1 million a year. There's no threshold. A relevant a company or a licensee who is doing a relevant activity is defined based on the main factor of if they are really doing one of these 9 activities or not. We go to the next slide. Can we go? Yeah, thank you. So I'll give an example with the holding company business. So holding companies can benefit from a reduced substance requirements. However, they are only applicable to entities with some condition. If they hold equity interest in other entities, so if the whole purpose of this company is to own shares in other businesses and they earn income from dividends or capital gains only, and they are not carrying any other commercial activity or any other type of investment, in this case, they will benefit from a reduced substance requirements. So an entity with a holding company structure that conducts another relevant activity, in this case, will have to meet the full substance requirements. In other words, a holding company business that its whole purpose is to hold equity interest and make money out of dividends, it will benefit from a reduced substance requirements, and they don't have to adhere to the full substance requirements. But if in case they are doing a holding company business, and in addition to that, they're doing IP, intellectual property rights, for example, we have to then identify which of them is generating the core income. So most of the income is coming from which activity. Then we will define if this company is going to be defined as a holding company or as an IP. And in this case, the requirements for fulfilling the economic substance requirement will apply to it. Because, for example, an IP is a high-risk activity, and thus it has to comply with the higher requirement test. Can we go to the next slide? On another example, an IFZA, which is one of the economic zones in the UAE, an investment in commercial enterprises and management activity. And this activity, for example, is quite different from a holding company that we gave it in the previous example. This example is a holding company that is not just holding the shares and making income out of dividends. These are the firms who are holding the company, and in order to invest their funds, they are basically contributing into the management. This happens a lot when it's a big operation or a big group, and there is one holding company that has a group CEO, a group CFO, and a group marketing, and a group other departments, HR, for example. And these divisions are controlling several subsidiaries or several other companies, and they're providing them with services. In this case, that's a different activity. And for this, the core income generating activities of a holding company business are all activities related to acquiring and holding shares, equitable interest in other companies, provided that such activity do not constitute another relevant activity. So this is a different example to a holding company business that will still be applicable, will fall under the economic substance requirements. I made these examples in the table to identify what will fall under and what will not fall under the economic substance regulations, and we'll go through them very quickly. We will send you this presentation later on so you can spend some time on it. So in the first example, if a holding of immovable assets like real estate, for example, and most of the income that is coming to this company is coming from the rent, the proceeds of investing of making the income out of the real estate. In this case, it will not fall under the economic substance regulation, and the company will not have to fulfill the requirements, and the company will not have to apply for an submit an economic substance report. But in the case of immovable assets, we'll have to identify whether, for example, it's a finance lease income. If it's a company is providing finance or lease services to other entities, then yes, it will be considered as within the scope, and it will have to apply for the economic substance tests as well as submit for the reports. But if the income in this case is coming from the sale of these movable assets, it would be not under the scope of the regulation, and it will not have to go through the test or submit, or has to do the test, of course, but will not have to submit the report. The third example here will be holding intellectual property assets, and intellectual property assets are basically like a trademark or a copyright or something like this, and this is always identified as a high risk activity because it can be easily used to move or to shift the profits from one entity to the other, and that's why it is always something that has to be looked at very, very well. So if the income from these entities who are doing the holding as intellectual property assets, the income in this company, for example, embedded in intellectual property, it will fall under the scope of the regulation, and it will have to adhere to the increased substance requirements as a high-risk licensee. Let's go for example number 6, because that's also interesting if it's a holding equity interests and undertaking another relevant activity. And the income from this equity interest and the other relevant activity are, the income for this company is coming from both. Then it will still apply to adhere to be within the scope, and the business activity in this case will not be the holding company business, and it will have to fall under the economic substance regulations, and it will apply also the high risk. Can we go to the next slide? We'll give some examples here to make it also a little bit more easy to understand how to identify these examples. If a company called ABC Limited only activity is holding shares in 4 subsidiaries companies, and ABC Limited itself is held by a regional holding company of the group headquarters in France, and the only gross income earned by ABC Limited are annual dividends from its subsidiaries. And in this example, yes, it will be considered as deploying a relevant activity. It will fall under the scope as a holding company. In the second example, if DEF Limited, which is another company, the main business is manufacturing of food products, and additionally holds the shares in another company which operates a restaurant. In this case, it will not be considered within the economic substance regulations because the main core income generating activity is not coming from one of the 9 relevant activities that we are talking about, even if it holds shares in another company. In the third example, if a GHI Limited holds 100% of the shares in 2 subsidiary companies and has provided an interest-bearing shareholder loan to one of these companies, GHI earns annual dividends and interest income. And in this case, you'll understand that this company is doing 2 different kinds of relevant activities. It's acting as a holding company, holding equity shares in another company, and it acts as finance leasing activity as well, because it's providing a loan and it's making a consideration out of this loan even to a connected entity, and in this case it will be considered under the economic substance regulations as well as defined as a finance lease business. Can you go to next slide? And let me go back, because it might be a little bit overwhelming of if it's a lot of information, or it might be not so clear. You always have to understand and identify what is the main purpose we are doing this. We need to understand that the purpose of this company establishment and operation is to divert profits from one entity to another, through one state to another, if there's real operation of this business in the state or not. So another relevant activity that we will make a little bit of a spotlight on is a service center business. And there is a broad scope when we talk about the service center business. So for example, it can be consulting, can be administrative services, but requires the services to have two very important conditions: a foreign connected person and in connection with their business outside of the UAE. So I'll give you an example. If there's an entity that exists in a foreign entity, exists in Europe, for example, and they have a connected entity in the UAE. And this entity in the UAE is doing business with their mother company or whatever is a connected company in Europe, and they're charging them fees. Okay, and it's in connection to their business. In this case, we need to identify, is this company in the UAE charging their mother company or the connected entity for whatever reason, is basically shifting some of the profit or providing services to them to outsource, to move this profit or move this income from one entity to the other. And in this case, we have to identify the test. So does not include providing services to third parties. So for example, this is one of the important points as well. If this entity in the UAE or whatever company in the UAE is providing services to third parties or third-party companies outside, then there is not a problem. It's not within the scope because it is not providing services to a connected entity. Because then if it's a third-party entity, there is no doubt that there is no maybe possibility for them to be shifting profits between them. The point here is to have it as a foreign connected entity and in connection to their business outside the UAE. So let's go for the example here. The main business activity of a company called TUV Limited is to operate, is to provide HR and administrative support services to a group company based in Kuwait, which is charged at cost. And when you charge a cost, you understand very well that you're probably providing these services to that entity at cost, and then you're probably reselling it or providing it to someone else with a profit, which means that you're shifting the profit from one country to the other. And in this case, we will need to prove the substance in the state to be able to understand that we are not misusing or harming the UAE in the sense that is using it in the wrong way or to try to evade taxes in a different state. Can you please go to the next example? So in the service center business, we're still in this spotlight. The following core income generating activities generally apply in relation to a service center business: providing consultancy or other administrative services that the SIGA covers the provision of any type of services to the licensee's foreign company. If an entity engaged in a transaction falling under this scope of a distribution service business, service center business, it's exempt from demonstrating economic substance in the UAE if it can prove that the transaction exceptional nature, such as being a one-off occurrence, for example, and it only charges relevant foreign group company at cost or less. So let me give you another example here. So there is this furniture brand, a big furniture brand in Sweden that has branches all over the world. So if Sweden mother company is selling their products at cost to the UAE subsidiary or to the UAE connected entity, and at the same time, the UAE connected entity is selling all the products, making all the profits here in the UAE. This will be an example to how the how there'll be shifting of profit. And that's why the company here, whether it is providing services to their mother company or doing business that is related to their business activity outside the UAE, have to prove that they have enough substance in the state. So they have operation, that they have people, they have office, that's real business behind it. Because in some other cases will be a shelf company registered in UAE or a paper company registered in Bahamas or in British Virgin Islands that is saying theoretically that we are doing trading and they don't have enough substance in the state. That would be just shifting the profits from one state to the other. And this is the core of how to identify if a company have economic substance in the state or not. Can you go to the next slide? Another relevant activity is the financing or leasing businesses. And these finance covers the licensees who are providing credit or financing for any consideration, including in the cases that it's between group members. So if a company is giving another company a loan or any kind of credit line or any kind of financial support in the business, and they are expecting a consideration out of it. So these activities can include lending to a related or unrelated parties, finance lease for assets, excluding land, for example, and various credit arrangements like hire purchase agreements. A consideration here is a very important point. So when we talk about finance or leasing business, there must be always a consideration to be considered a finance and lease business, and then to consider be deploying a relevant activity. So for example, if, again, I will talk about Elnaggar and Partners because it's easy. If I have Elnaggar and Partners in Sharjah and in Abu Dhabi and in Dubai, and between these two entities, I need to be shifting some cash or some money to be able to pay salaries or to pay rent or to do some of the expenses, and I'm not making any interest on it, then they will not be considered as a finance or leasing business, even if I am actually providing a loan, because there's no consideration in it. But if it's coming with a consideration, then coming with a profit, or I'm charging a penalty on a related company, in this case, it will be considered as a financing or leasing business. There are some exceptions to this rule on UAE businesses. Sorry, if you go to the last point, yes, exceptions if UAE business not expecting consideration from the credit at the time is provided and not considered his finance business. So what's important in this point is at the start of this loan or at the start of this finance leasing services, the entity was not planning to make any income out of it. So for example, I'm going to give a car, and after 1 year I'm getting this car back, but in reality this car value or even a real value, or I don't know, crypto for example, the value have gone much higher, and by returning this or by earning this again, I'll be making basically profit out of it. The most consideration is that this is something that I was not planning to have. I'm not planning to have this consideration. In this case, it will still be the only exception where I will be able to make income or make profit, but will not still be considered as finance leasing because I did not plan for this. It just happened. There we go to next slide. And in order to be able to identify if the finance leasing business is existing in the relationship, there must be agreeing on funding terms, identifying and acquiring assets. There must be setting terms in duration and finance or leasing, monitoring or revising these agreements, managing any risks. So must be a set of terms or any of these points that exist to identify if we are doing a finance leasing business. I'm a bit running because I'm aware of the time. I know the subject is very much time consuming, so I'm aware of the time, trying to make the best out of it. Can we go to the next slide, please? So the economic substance test, when a company is found to be doing relevant activity, so we have to understand that there are 3 tests that we mentioned at the very beginning with reference to the level of relevant activity performed and related core income generating activity in the UAE. we have to understand if this company have adequate number of qualified full-time employees in relation to the activity who are physically present in the UAE. So I cannot say, for example, I am running a business of $10 billion and I have 3 staff. Makes no sense. So this is not equivalent to the turnover of the company, and not equivalent to having a company that is doing lease finance examples for, I don't know, 100 contracts every month, and I have 3 or 2 employees. So the adequate number of qualified full-time employees in relation to the activity are physically present in the UAE. You cannot have a bank running with 10 people, for example. So that's something that has to be looked at. Adequacy operating expenses. So also a business that is running and making a turnover of millions of dollars cannot have expenses of $10,000, $20,000 a year. It makes no sense. And it has to have a kind of relevance into the business activity and the norms of it. We must check if there is adequate physical assets and premises to carry out the relevant activity from in the UAE. So if the company, for example, have no address in the UAE, they just have a PO box address or a registered address within their consultant office, and they are working remotely, but makes it very difficult to understand that this company have economic substance. And by performing this test and checking these details for every company, you'll be able to understand if it does have substance here in the state or not. On the other hand, the core income generating activity, as per each relevant activity undertaken in the UAE, we need to understand what is the core income generating activity in that company. And based on the core income generating activity test, we'll be able to identify which relevant activity the company is deploying, or whether it is not deploying any relevant activity, and thus it falls outside of the regulation and does not have to report it. And the last test, which is directed and managed in the UAE. So this is particularly very important to understand that this company is not used to bypass the regulations or to use as if it exists in the UAE. It must have holding its board meetings here inside the UAE, which decisions are taken here. Quorum is met by the directors physically present here, managed members of meetings properly recorded and signed by the directors physically present here. Because if you're saying a UAE company, it must be some substance in it. There must be some presence in UAE. So I cannot imagine that a company that has enough substance here and enough business will be 100% managed remotely. That doesn't work very well. Branches and entities with one board member must be in the UAE when making key decisions. So if the key decisions are taken to liquidate or to pass assets, to sell them, to do something like this, they must have some connection here in the UAE. So that's what it means, directed and managed inside the UAE state. So now we understand what is economic substance, what it's all about, and we need to identify what do licensees need to do. And in this case, licensees must inform the Ministry of Finance in the UAE about their undertaking and relevant activities, whether they're undertaking relevant activity or not. And the first thing that they have to do is to submit their economic substance notification, which occurs every year within 6 months after the end of the financial year. And only the licensees that are not exempt, in fact, to do or undertake the relevant activity, have to meet the economic substance requirements and file for the economic substance return on an annual basis. Can you go to the next slide? This is just a quick demonstration of the timeline since the regulations started in 2019. So any company that existed before 1st of January 2019, the regulation doesn't apply to them. And the companies that existed beginning of January 2019 and continued to exist after that until the 31st of March 2020, they have to be reported. Of course, now we are many years past that, so you have to look at it in this sense. Some companies have their financial year as a calendar year from January to December, and some other companies have it a little bit pushed, like starting in the 1st of June. Whether the company starts here or there, it doesn't matter. So from the end of the financial year, you have 6 months to make the notification for the economic substance, and another 6 months for those who have to report to actually submit the report within the time. This saves us this slide and the next one, I guess. Yeah, you can go there. So here's the serious part. I mean, we're talking about all the regulations, but now the consequences of not being in compliance. So failure or being late to notify will attract a penalty of up to 20,000 dirham. And based on my experience, there's no up to, because the Ministry of Finance applies these penalties by the book. So the penalty of 20,000 dirham is for all the companies that should notify and they don't, and all the companies that is found to be doing relevant activity and they don't not make the notification will be filed with a 50,000 dirham, and this deemed failure to demonstrate economic substance test for each financial year, and submission of or even if they just submit inaccurate or wrong information deliberately, then they will be fined a 50,000 dirham. A failure to demonstrate sufficient economic substance in the UAE for a relevant financial year, that is something that is being taken very, very seriously. And if you repeat it in the second time, this may result into automatic information exchange with the tax authority or with a foreign state where you are basically misusing the UAE structure for, and an administrative penalty that goes up to 400,000 dirham, and the UAE authorities reserves the right to revoke or suspend or withdraw the license itself. Yes, by this I end the information, and I would like to thank you very much for your patience and the time. Here you have the QR code to download and have access to the notification and to the report of Ministry of Foreign Affairs. Thank you very much for listening, and please feel free to ask any questions. You have my contact details here. You can reach out to me at any time. Thank you.